Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. Girl, you gotta hear this one.
Hey everybody, it's the Squid. Welcome back to the channel. Today is Friday, and it's the Fridayiest of all Fridays. I've been so busy since the moment I woke up this morning, and I wasn't sure that I actually wanted to stream because I have a hella headache. But we have so much shit to cover, and excuse my language, but we have so much stuff to cover that if I don't cover some of these things, I'm going to get behind, and I'm already behind on content. I have 30 videos to record about stuff for the NTSB dockets for various crashes. I have videos to record on my other channel. We have documents in different cases. I wanted to do a chill stream this Friday, but I didn't stream yesterday because I wasn't feeling well, and the little wasn't feeling well, and we needed a mama day. However, with that being said, we have to talk about a couple of things. This is going to be a relatively quick stream, because like I said, I have a headache. I would rather be taking a nap right now because the rest of my family is pretty much taking a nap. Yeah, and hey, Mom. So after I get into introductions, we are going to get into, I checked the Orange County docket for like 5 cases because Orange County, Tiffany Moore Russell, I doubt she will ever see this. I doubt she will ever know who I am. But if any of you happen to see this and know who she is or know her personally, she is freaking amazing. She is the clerk of courts for Orange County, which is Orlando, Florida. Her website, whoever she had do it or they had it done or whatever, this woman's website is so easy to navigate. It's probably the easiest in the entire country. With that being said, there's Orange County is the craziest county in the country. I believe 4 cases. There's Sarah Boone, Anthony Shea, Lips, and the whole Jeremy Hales shit show is also in Orange County. And well, I just so happened to check Sarah Boone's docket because I'm looking for updates in her appeal. So I always check that docket before I check the appeals website just to see if there's anything there. Well, December 2nd was a handwritten motion from none other than Saint Sarah of the suitcase herself. So we are going to get into this because we all miss. I say that as sarcastically as possible. All of Sarah Boone's handwritten motions. Bubbles, take note because Sarah sucked at being a lawyer, or but she still wrote better motions than you did. Just saying. All right. So she handwrites motions and she still writes better than Bubble Brain. We're gonna get into this. Motion for defendant appellant Sarah Boone to be included and added to the certificate of service by all parties to receive important information regarding her appeal and the process of. Sarah wants to be a pick me girl. Pick me, pick me, pick me. Tell me, tell me, tell me, tell me, tell me. She does oh Gail, oh Gail, oh Gail, oh Gail. Go back. I have an entire Sarah Boone playlist. Sarah Boone wrote all her motions when she was pro se by hand from jail. And she still did better than Bruce. I mean, she fancied herself a pretty damn good lawyer. And she did win a couple of motions, surprisingly enough. But this is, in my opinion, this is just now her being a pick me, pick me, pick me, because she went through 9 lawyers. And now she's been through 2 appellate lawyers and she still doesn't have an appeal in that I checked. We're gonna check after I'm done here. We are gonna check. So motion for comes now defendant appellant Sarah Boone and respectfully requests to be rightfully included and added to their certificate of service in correspondence filings produced by all parties in her appeal, including and foremost from Orange County Clerk of Court, Judge Michael S. Kranick, 6th District Court of Appeal, Attorney General, Criminal Appeals Board, all counsel of representation, former and present, any future parties to be included in this matter. In support of her motion, defendant appellant states the following. 1. Sarah Boone is the other primary party in this case for her criminal appeal. Yeah, yeah. It's only because it's a five-page motion. The more agitated she gets, the worse her handwriting gets. Yeah, and if you've checked out Jumpsuit Pablo's channel within the last few weeks, he's been releasing her jail calls, and she's something. She was sentenced in her criminal case on December 18th, 2024. Due to her indigent status, the court appointed an appellate attorneys to represent her during the appeal process, where she is still waiting to understand whom her present attorney is, and status is from no information provided by the Orange County Clerk of Court, Judge Kranick, or the 6th District Court of Appeals, or any direct contact made by the attorneys themselves. I think Sarah Boone is a shitty human being. However, she kind of has a point. She kind of has a point. If you have a lawyer, that lawyer is supposed to be in contact with you regarding what's going on with your case. And I would be pissed too. This is where the process of just because I don't like somebody doesn't mean that I think they're always wrong. And this is where, oh yeah, Sarah, she back. She back, baby. For TLDR, if you do not know who Sarah Boone is and you've been living under a rock, or never were part of any LawTube adjacent, or anybody ever covering court cases on YouTube before the you came over from Jeremy Hales. Sarah Boone in 2020, either February of 2020 or February 2021, decided to zip her boyfriend into a suitcase where he did not make it. I'm trying to think of how I can say this. I'm trying to think of how I can say this without being needed from YouTube. She claimed they were playing a game of hide and seek. Grown ass people don't play hide and seek even when drunk. I've played hide and seek, but I have a 3-year-old, so there's a reason for that. Hey Joe. Celebration of Boone being back. I'm gonna pick up a bottle of Boone's Farm on my way home from work. Oh my god. Oh, okay, not really. It used to be the cheap thing. I don't think it's the cheap bottle anymore. I don't know why, but everything's expensive these days. However, she was so intoxicated that she did not realize that she recorded herself, and ever so kindly, when the cops asked for her phone at the scene, she gave them her phone. She had recordings of her saying things while he was zipped into a suitcase, basically begging for her to let him out. And that's how she got the name Suitcase, or Saint Sarah of the Samsonite. She was found guilty, so that is no longer a alleged crime. That is, she did it. She is on appeal. But since her appeal, her appeal has gone nowhere. Nowhere. There's been no appeal placed. She had one attorney appointed, and they withdrew due to a conflict of interest. A second attorney has been appointed, and we'll read that order that was placed on the 26th. Since, but she was found guilty, or she was sentenced. She was found guilty in October because she was the first trial I covered as a monetized channel. Thank you, Sarah. At least you're good at something. However, she was sentenced December 18th. We are almost a year since her sentence, and her appeal has gone nowhere. I don't think she's going to win her appeal. I think it's stupid for her even trying to appeal, but it's her right. However, she has not talked to, and I still have her sidebars to go through. I have the entire transcript of her trial and sidebars that I want to get to that I still haven't gotten to. Like I said, so behind. There's so many things I want to talk about and cover. It's just how many, you know. Yeah, you old. Just kidding. But to not, so I don't like her by any means. She is somewhat entertaining at times based on her attitude. However, to not hear from her attorney, especially court-appointed attorneys, I'd be pretty, yeah. I've gone through some of them. I have to go through the whole transcript is thousands of pages, but the thing is I'm a one-woman show here. So until Papa Squid moves down here and starts helping me out with my channel, or babysitting so I can do stuff with my channel, there's that. Which the fact that the little called him 3 times today and just wanting to hang out with him, she didn't want to talk to him. She just wanted to have him there watching her. So she probably will go over to his house a lot, just to, But let's get back into this, because I don't know how I feel about this. And I always feel dirty when I agree with Sarah on something. Due to her indigent status, the court appointed an appellate attorney to represent her during the appeal process, where she is still waiting to understand whom her present attorney is and the status from no information provided by the Orange County Clerk, Judge Michael Kranick, or the 6th District Court of Appeals, or any direct contact made by her attorney themselves. I don't think that the clerk of court the judge or the 6th District Court of Appeals have to talk to her. But I think it's shitty that her attorney hasn't. Just saying. Drive safe. Since her sentencing and ongoing a full year since being transferred to the Department of Corrections, she is not properly and fairly included in receiving copies of general correspondence, withdrawals, spelling, Sarah, updated attorney contact information, extensions, judgments, amendments, essential filings between or directly from other parties listed above. Wherefore, in order for the defendant, appellant Sarah Boone, the other primary party to be rightfully included in her case and informed as the aforementioned, she is requesting to also be included in the certificate of service on all future filings, to receive appropriate copies via United States Postal Service through Department of Corrections legal mail, or until appointed counsel is established to do so accordingly. Uh, I don't. Hey, Sarah. I don't see. I'm one of those people that I like information. Like, I'd like to know what's going on with shit. Especially since I'm sitting doing this all day. If I were her, um, you know, we're just gonna skip past her current address. But she even writes out when she handwrites. She even handwrites her certificate of service. She handwrites her certificate of service better than some lawyers I know, and that's a sad world I live in. Uh, let's see. Uh, Here we go. So she sent her this motion to the Attorney General of Florida. And there's her. If you ever want to fan mail her, go to Orange County Clerk and you can get her address. I don't recommend it, but it's possible. So this is the order from the judge or Attorney David Maldonado is counsel of record for appellant. Because appellant is represented by counsel, the motion filed pro se and docketed November 20th is stricken as nullity, which is the last thing she filed, which was this. Notice of inquiry and order appointing Office of Regional Conflict Counsel. So there's just been a bunch of orders for extensions of time and things like that. There really hasn't been anything of note in her case, but this is the first time that that's the first time I've seen that she's written a handwritten motion since her trial, and it was kind of like, oh, we got to read this. She wants to be a pick me girl. Include me, include me, include me. But the sad part is, um, what, you can't fix her? An unknown hero is married now, so he can't fix her either. That was the running joke for a long time. Because I did stream the trial. However, we're going to look at the 6th District Court of Appeals website and see if there's anything in there from that. Please say I have it saved. Florida District Court of Florida appellate case information. I do have it bookmarked. Search. Party search. Appellant Sarah Boone. We're just gonna see if anything is in her thing. Today was kind of one of those days where it's like when you have so many things to talk about, but yet you don't really want to talk about anything. All right, there was a notice. Let's see. So this is the Court of Appeals website, just in case you haven't seen it before. It's really easy to navigate in Florida. So crazy. There was 12-1 notice of agreed extension of time for an initial brief. She still hasn't had her initial brief, like her initial appeal brief in a year. Like it's so weird. There's only 2 pages. All right. So this is just a notice of extension. Once again, not dramatic, but important to the timeline. Notice of filing agreed extension of time for filing initial brief. Comes now appellant Sarah Boone by and through undersigned counsel pursuant to Rule 9.3A of the Florida Rules of Appellate Procedure and Administrative Order 23-03 of this honorable court, and hereby gives notice of filing of below agreed extension of filing for the initial brief. The undersigned counsel for the appellant has agreed with counsel for the appellee that the time for serving the appellant's initial brief may be extended 60 days to February 1st of 2026. I am writing that down as we speak, so that we keep checking, because now we have an actual date. Well, February 1st is a Sunday, so yep, we'll see how that goes. Sarah Boone. Appeal due. See, I have to write it down, otherwise I'm gonna forget. This is how our brain operates. So that is all our Sarah Boone news for today. Another thing that I really wanted to talk about today that I haven't quite been I was kind of looking up, but I haven't quite got there yet, is I was reading some local news stories from back home. And there has been an international incident, shall you say, where on 11/21/25, criminal complaint was filed against a Justin Dirk Kagenbauer from Muskego, Wisconsin. Um, a an, I'm not exactly sure who. They just said undercover investigator or member of an investigative team was texting him from London. I believe it was from London. It was somewhere in England, acting as a 9-year-old girl. 9-year-old girl. He said that he wanted to fly to London or fly overseas to see her and have smexy time with her. That it would be a dream come true. She's 9. Well, she was acting as 9. The person who was actually texting him was not 9. She was an investigator. However, we are going to just skim this because I will be reading this full complaint later this week, or not later this week, next week, probably Monday. This is the preview of next week because we are reading his arrest warrant is the first page. And guess what? Guess where Muskego is? Yet again, you've guessed it right. Everybody's the most infamous county in Wisconsin. Waukesha. If you don't know Waukesha County, think Darrell Brooks, think Slender Man, think Nikita Kassap, which I still have to convince somebody I know in Wisconsin to go to the courthouse and get those documents for me. But this is where we use our PACER. This is where we use our powers of PACER to get out all of the people So we hold on, I have to stop sharing this for a second because I'm not sharing my tab. I'm sharing my whole window. There we go. I, complainant in this case, state the following to true and the best of my knowledge. 3/13/2025 through 11/27/2025 in the county of Waukesha. 18 U.S. Code 2423B, attempted travel in interstate or foreign commerce with the intent to engage in illicit smexy time. 18 U.S. Code 2422B, child enticement. And 18 U.S. Code 2252A2, distribution of child porn. Yeah, yeah, and that's the county I'm from. I will be putting this as a separate video. Um, oh, and our favorite judge, Nancy Joseph, she is the one who turned down. Oh, and there's updates in the Hannah Dugan case. So I might just update this thumbnail and this description of this video to just be doing end of week wrap up, end of week crappy updates. Affidavit in support of a criminal complaint. Yeah, we will definitely read through this whole thing on Monday. So I am currently saving this because when I pay for a Pacer document, guys, I save the shit. So y'all know I save it so that we are not having to pay for this twice because that would suck. Document 1, criminal complaint. I use my powers of Pacer to expose crappy people. Because this would be because Gail, this would be a 2 or 3 minute news cycle, news report. I saw it on an Instagram reel for Channel 12, and then it would get buried again, and they would move on to other shit. Whereas I am going to keep calling attention to this crap, and we're going to see this shit through. So sometimes it gets a little slow on this channel. That's because we follow the documents to the case's completion. Sometimes the cases don't get complete, and we have to kind of cut it off at the ending. Like some of our cases, like Christopher Schultz, he took a plea deal and then self-deleted. Case over. Not really, you're going to hear about that anymore. Mia Bailey out of Utah took a plea deal. We can't cover that case anymore. I start covering these cases from the very beginning. Not all of them go to trial. Hey, Auntie M, lurkers are people too. How are you? Yeah, and I don't want to. There's certain things I don't want to talk about, or I think is like it's hard to talk about because this is a child enticement issue. However, if we don't expose these people for what they are, they go around in normal society instead of the sexy time, the deviants and demons that they are. Like these, these are an interesting. Oh, and there's also a case out of Florida that I was sent that I'm going to be looking into out of St. Augustine. I was sent a press conference. Kind of a woman had a I didn't see the whole press conference because I got busy doing things, and my attention span when I'm trying to, manage 30 things at once is I get highlights, but not every detail that should be important slips in the first time. With that being said, uh, it's a case of an order of protection and a kind of a love triangle-ish. Um, yeah, somebody tried to escape a hard relationship, and you know, yeah. Hey, Snipe Hunter, how are you? And Calvin, good to see you. All right, so I'm saving this, and I'm having to make a new folder. So federal cases, because I'm using my power of Pacer for good. Federal. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 federal cases right now. 10 if you count Jeremy's. 10, 11, 12 if you count Jeremy's. What was his dude's name? Justin Hagenbauer, the most Wisconsin name ever. And I'm still looking for links to see if they'll press federal charges against Nikita Kassap, considering he was part of Order of Nine Angels, and they had a plot to assassinate the sitting person in the White House. So even though it's a Waukesha County case right now, it might be a federal case. I haven't checked up on it in a while. So we'll keep that in mind too. Okay, that one's good. Now we have oh crap. And I didn't save that case. No. New search, case search. I'm currently searching uh Pacer right now. Kagerbauer. Ugh. Justin. I have to put a little star by the case to save it to my saved cases so I don't have to go searching for it. Even that search cost me 10 cents. Like even searching the Pacer thing, having the party search where all I had to do was put a star by it cost me 10 cents. Yeah, I'm trying to be responsible with it though. And now we have to go back to saved items, saved cases. Saved cases, come on. Let's see. Oh, we still have if anybody's interested, uh I have Robert Kesey's or US Court of Appeals for the Third Circuit appeal documents, his entire case. And USA v. Glades Herp Farm et al. Robert Kesey. So I have hit in the Pennsylvania Eastern District Court. I still have those cases too saved here if we want to go through those. Just in case anybody's interested in actually going through those documents and exposing what the fuck is his name? Blue tape chick's dad. Gator dude. Oh. All right, let's see. Where is USA versus Dugan? There's a new document. There's a new document in Hannah Dugan's case too. Hannah Dugan is the rogue judge. Judge gone rogue. Backdoor judge, however you'd like to describe her. Trying to think of what the document is. Oh yeah, and that's why I love covering federal cases, is because federal cases you don't get any trial coverage because there are no cameras. All you get is the documents, but you have to pay for the documents. So a lot of people don't cover them. So this is her docket right now. So this is her docket. We covered the letter from the US. So there's all of these sealed documents, but there's more. We have her motion to exclude portions of audio recordings, which I think I saved because that was another case that I was like, I need to take this on, but I don't have time. Well, and we're gonna make time. USV Hannah Dugan 77. Yes, I did save this, and it is short, sweet, and to the point. So it's 5 pages. So these are perfect. These little 5-page motions, we can go through these relatively quickly without side door judge. Let's see. All right. This is her defense motion in limine to exclude portions of courtroom audio recordings. What are you trying to hide? What are you trying to hide? Why don't you want your courtroom audio um, to be shown or to be listened to? If you didn't do anything wrong, why don't you want your courtroom audio? Obviously, they're not going to play stuff that's going to out victims or anything of any other court. They're limiting it to, you know, your wrongdoings. So why don't you want evidence? All right. Defendant Hannah Dugan, by undersigned counsel, hereby moves pursuant to Federal Rules of Evidence 402 and 403 to exclude portions of courtroom audio recordings evidence when defendant Hannah Dugan is not present. Background: the government has produced to the defense courtroom audio recordings that cover approximately 33 minutes of activity within her courtroom. The first segment is approximately 17 minutes, consisting entirely of conversations between court staff, attorneys, and parties, all prior to Judge Dugan taking the bench without her in the courtroom. They include statements and discussions about ICE agents in the hallway, specific pending case discussions, including plea negotiations and casual conversation. The speakers use profanity, including salacious comments about ICE. Oh, let me grasp my pearls. Yeah. Well, here's the thing. My situation is, if you know you're being recorded, you should probably not say certain things. If you know you're in a courtroom and courtrooms are being recorded, hey, Cynthia. Yeah, I truly want to hear that conversation too. Yeah. Oh, sidebar. I truly want to hear that conversation. However, she's playing pick me. She wants to be included on every document filed and everything. She wants to be included in the certificate of service. So there has been lawsuits filed in the Louisville MD-11 plane crash from a few law offices, one in Louisville and one in Chicago. They're working together. I have reached out. I doubt I will hear anything. Because I'm such a small channel. However, I did reach out to the law firm in Chicago. I grew up here, and I emailed the PR person for that case because I have a problem just emailing attorneys, like asking questions. However, I don't have a problem emailing asking for documents when they have a press release with a PR person for information. Please email this person. I emailed that person asking for all the documents related to the court or the case against UPS and Boeing. I think there was more people involved in that lawsuit. I haven't heard anything back yet, and I doubt I will. I'll probably email again next week if I don't hear anything, because I'm going to be annoying, because I've covered all things NTSB on this case or on this channel. So when I cover aviation and then I cover lawsuits, and aviation and lawsuits kind of go together, then I'm like, oh, I'm definitely covering that lawsuit. You grew a pair, just sign up the pair you have. Oh boy. Yeah, they were relaxed. They had gotten away with stuff before. They didn't care. Yeah, and I want to hear those conversations. And I believe those ICE agents should be able to hear what's said about them. I mean, right? If people talk shit about you, how are you? It'll probably end up in the federal courts, possibly, but right now it's in Louisville. And I did find out that the Louisville attorney who is covering it is not the person who is handling Bubbles' case against Larry. I did find that out because I wanted to make sure that before I started covering this and starting acting nice to the lawyers and you know, that this wasn't a shady lawyer. I wanted to make sure this was a legit lawyer, and everything I could find about him says legit-ish, as legit as a lawyer can get. Speaking of that, I might have Florida lawyer. Might have a Florida lawyer to talk to as a contact. I might have a friend um, just for shits and giggles. It pays to know people, and apparently, okay, I got a notification, and I'm like, I'm not taking chances. Okay. The Louisville one is probably local counsel with the Chicago office taking the lead. Yeah, it's local counsel in Louisville. It is, come on, I had that. You always know when you have something and you close it and you're like, why did I close that? Because I'm gonna need that information in like a second. It is show full history. And I know I got sidetracked, but I wanted to I know I would forget to mention this if we didn't talk about it now. Um I should have saved it. I don't know where I saved it. Oh, there we go. Nope. It was a law firm in Chicago. I have the information somewhere. But I did. Oh yes, right. Oh, right here. I'm looking right at it. It is Clifford Law Offices in Chicago. And it is Bradley Cosgrove and the law office of Sam Aguiar in Louisville. So they did put out a press release, which we can actually go through in a second. I think I did, but I don't know. I kind of don't know what you were talking about. So, can you clarify what your question was? Because I got confused. Maybe I just didn't understand. Maybe it's just me. And hey, Sister Sal, how are you? Lurking while at work. Good to see you. All right. Squid in one ear, Black Ops 7 in the other. Perfect Friday. Yeah, and I need to go relatively soon because we are I have steaks that I seasoned this morning that I would kind of like to cook. Since the little yesterday when I took out steaks to season them, she slammed the kitchen door on me or the refrigerator door on me and said, "No, no, 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 no." Today she actually let me do it. Just still lurking in the rain. Oh, it was cold this morning and rainy. Oh my God, it was miserable. Maybe that's why my head hurts. All right. So getting back to this, approximately 17 minutes of a discussion between court staff, attorneys, and all parties prior to Judge Dugan taking the bench without her in the courtroom. They include statements and discussion about ICE agents in the hallway, specific pending case discussions, including plea negotiations and casual conversation. The speakers used profanity, including salacious comments about ICE. Suck it up, Buttercup. That's what happens when you cuss on camera. It, like, nope. In the second segment, approximately 7.5 minutes long, Judge Dugan is out of the courtroom for approximately 2 minutes and 45 seconds, during which she is involved in the encounter with the ICE agents in the hallway. While she is gone, similar conversations as in the first segment take place, including an attorney and his client discussing specific case strategy. Sucks to be them. The attorney cautions the client to be quiet because of a concern that the conversation may be picked up on the microphone and be recorded. I'm sorry, that's like if you're in a courtroom or if you're in public, assume you're being recorded. Assume somebody, Big Brother's always watching. So assume either the courthouse is recording you, a traffic camera is recording you, or somebody else with a cell phone is recording you. Always, if you are outside of your house, assume you are being recorded somewhere, somehow. Whether it's a neighbor's security camera that just happens to catch your door too, assume you are being recorded. Like, um, generally they're air show specific, but there's not a whole lot of modifications. Usually it's like paint jobs and shit like that, and the fact that you just can't load weapons on them easily. But I can ask Mr. Squid because he would know because he loaded weapons onto airplanes for his job. So he, yeah, yeah. This is I believe this is a desperate move. I believe this is throwing shit at the wall to see what sticks. But if you're carrying a cell phone, you're being recorded. Yeah, I feel like my cell phone always listens, but I was seasoning those steaks today and I was trying to figure out what the weather was going to be like because I wanted to try to plan them to cook them because I'm cooking them outside when it's not raining. Um, and my phone, when I said Siri, didn't actually want to listen to me. So, yeah, it's it you know, they're generally air shows, like, they're assigned to that squadron, but, like, in a pinch. So, like, say the Blue Angels, those are jets assigned to that squadron. That is not a deployable squadron, so therefore those jets aren't dep mission ready. However, they're not far off. They would just take a couple of switches here and there nothing is taken out of them for them to be air show jets. They're just from a squadron, so, like, they might not maintain the pew pews kinda stuff because they don't need to. They might maintain them minimally to keep them, like, non-corroded, but, like, they don't actively use them, so they don't need to maintain those systems. For their jet to be airworthy, it doesn't have to have working guns. Whereas say a deployable squadron of F-18s or F-35s would need working weapon systems in order to deploy for obvious reasons. So they're not there's nothing taken out of them that I know of, to make them air show worthy besides the paint job. So, no problem. This is my thing. You should not talk in public if you don't want it recorded. Everything you say in public. That is why be careful what you say wherever you are. That's why there are some things that you might think, but you shouldn't say. Because generally speaking, 9 times out of 10, when you go in public, you are always being recorded. So, uh, at a later point, Judge Dugan is outside the courtroom for approximately 30 seconds, during which court staff and others discuss ICE arrest, and an attorney separately talks about discovery and a plea deal using profanity. That's a him problem. Oh, thank you. I couldn't, as of like 2 days ago or whenever I emailed yesterday, they weren't public yet. Um, the only people who had them were the people reporting on them, but they hadn't actually posted full documents yet. But thank you. Um, so I had emailed the law office because I'm like, maybe I can grow a pair. Um, Especially if you're around a Tesla, they always record. Always record. The third segment, approximately 9.5 minutes, overlaps slightly with the second segment. Judge Dugan is in the courtroom the entire time, so no objection is made on that basis. Legal standard, and there better be a tight legal standard on this, because I am like, if you are being recorded, that sucks. If you record yourself, you post it somewhere, it's posted, it's put into a court record. It, that be careful what you do and say on the internet or in public. It's just, I mean, if you're in a courtroom, you damn sure better know that you're being recorded. Federal Rule of Evidence 402 excludes irrelevant evidence. I don't think that's irrelevant. Evidence is irrelevant if it is wholly unrelated to the defendant's guilt or innocence and is not necessary to prove guilt. U.S. v. Hidalgo Sanchez. Evidence that meets the low threshold of relevance may still be excluded if the probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury. I don't know. I think it's a pretty damn good, it shows an indication of the attitude and the, what's the word? Y'all, Gail, finish my sentence for me. The environment in that courthouse of what those people were all thinking about ICE and how they handled it. And yeah, nope. It's like the interns that got caught doing, yeah, ugh, yeah, no. No. I don't want to come off as a conspiracy theorist, but I'd be damned if the government listens to everything. I'm pretty sure. Uh, undue delay, wasting time, or needlessly presenting cumulative evidence. Culture. The culture of the courthouse. Gail, I figured it out. To determine whether evidence is unfairly prejudicial, the court is to apply a sliding scale approach. As in the probative value increases, so does the court's tolerance for the risk of prejudice. U.S. v. Earls, also U.S. v. West, trial court's determination on admissibility of evidence rests within the sound discretion under the facts and circumstances of a particular case. U.S. v. Dukes. Analysis. Oh, thank you for analyzing it for me. Yeah, shows preconceived ideas relating directly to her actions. The audio recording of courtroom conversations and actions during which Judge Dugan was absent should be excluded under 402 and 403. There is nothing probative of her guilt in such statements, and if there were, such minimal probative value would be substantially outweighed by Rule 403 factors of unfair prejudice, confusing the issues, and misleading the jury. Courthouse culture says a lot. In short, such evidence would seek to convict Judge Dugan based in part on third-party conversations to which she was not a party, never heard, or even responded. As outlined above and set forth full in the under-sealed transcript, I really wish I could get hold of that. The segment consists of 17 minutes of third-party conversations entirely outside the presence of Judge Dugan. The speakers use profanity and include salacious comments about ICE. That's their problem. That's their problem. Like, the second segment includes similar banter, albeit on a shorter duration, since Judge Dugan is out of the courtroom for approximately 2 minutes and 45 seconds, during which she is involved in the encounter with the ICE agents in the hallway, then for approximately 30 seconds. Still, the conversations in her absence include court staff and others discussing ICE arrest, and attorney separately talking with his client about discovering a plea deal. Well, that's a you problem. Footnote, while the government likely will call some of the third-party speakers as witnesses at trial, unless all speakers are called, confrontation clause issues might arise. She was looking for culture. Yep, the word I was looking for was culture. I figured it out eventually. Accordingly, the referenced evidence should be excluded. Yeah, no, you're from Thiensville. You can go to hell. Ask me how I feel about Thiensville. Sorry if you're from there. All right. So we just have the we there we go. We just have the response from the US, which was yesterday. Written by Keith Alexander. This is 7 pages. This will be the last document we'll cover, and then we will head out for the day because I gotta cook dinner. Let's see. I'm making sure to save this before I start reading it. Lake Geneva. Who's calling me from Lake Geneva? If it's important, they'll call back. 12-4. Human 84. There we go. It would help if I opened it. Alrighty. This is the last document. This is the response from the US. Let me just get a drink. Lake Geneva. This has tentacles attached. Wait, what? Tell Spawn I'm sorry for getting someone yelled at in the stream because no, you're fine. It's fine. It was one of those things where in that instance, the when YouTube started using the handles, people's ats, it's different than their screen names. So that screen name is those 2 words, but his at name is his full actual name. So Spawn didn't know that. Once he figured that out, he apologized because it was his misunderstanding, not y'all's. Once he figured out what was actually going on, because sometimes it's really hard when you see random comments in chat and you're not really paying attention to chat, and all of a sudden something's happening and you don't know what's going on. It's like, guys, hey, and then it's like later when you're filled in on what actually is happening, and it's like, okay, it's not as bad as I thought it was. So, yeah. All right. Response to defendant's motion in limine to exclude the courtroom audio. U.S. by its counsel hereby responds to defendant's motion in limine. The U.S. does not oppose most of defendant's request. However, the U.S. requests that the court allow admission of the slightly more than 3 minutes of audio that captures activity after court was called into session on the morning of April 18th, but when the defendant had stepped out of the courtroom. The U.S. agrees with the defendant as to nearly 30 minutes of the approximately 33-minute audio recording. Interesting. It does not oppose the defendant's request to exclude the 17 minutes that occur prior to when court was called in session. The U.S. also agrees that all of the audio when the defendant is in the courtroom after court is called into session is admissible. The only points of disagreement relate to 1, the approximate 2 minutes and 45 seconds of audio that's captured after the defendant left the courtroom following court being called into session that morning. And because remember, she did this when court was called into session. So she was in the courtroom and left the courtroom. It's not like she just did this from her chambers and stuff like that. So we have to take that into consideration as well. And the approximate 30 seconds of audio captured discussions that occurred when the defendant was near and exited briefly through a jury door with EFR and his attorney. Evidence is relevant if any tendency to make a fact of consequence more or less probable than without the evidence. Federal Rule of Evidence 401, a fact of consequence is not limited to the ultimate issue or elements in the case. Rather, a fact of consequence can be any step along a path of inference that leads to an ultimate fact. Old Chief v. U.S. It does not matter under Rule 401 that there are multiple evidentiary routes. Doesn't matter how many roads there are to get there. Oh my goodness. To the ultimate fact other than the one relied upon by the proponent of the evidence. To be relevant, the evidence needs to be need not conclusively decide the ultimate issue in the case, nor make the proposition appear more probable, but it must in some degree advance the inquiry. U.S. v. Causey, quoting Thompson v. City of Chicago. Of course, relevant evidence may be excluded under Rule 403. Relevant evidence may be excluded only if its probative value is substantially outweighed by unfair prejudice, misleading the jury, or confusing the issues, undue delay or waste of time, or needlessly presenting cumulative evidence. Federal Rule of Evidence 403. Approximately 2 minutes and 45 seconds of audio that captured events in the courtroom after the defendant left shortly following the court being called into session is relevant in at least a few respects. For instance, it will demonstrate that EFR and his attorney were not at counsel table during that time. Another criminal defense attorney and his client were instead at counsel's table. Based on their conversation with the defendant after she had taken the bench, this defense attorney clearly expected his client's case to be called first. Fancy that. The microphone at counsel's table largely captured WP's conversation, not EFR's conversation or that of his attorney. Both WP and EFR's criminal defense attorney are expected to testify at trial, and the audio will corroborate both of their recollections and expectations at that time. Interesting. Evidence corroborating a witness's testimony is relevant under Rule 401, even though it has nothing to do with a defendant. Ooh, sorry. This guy's laying the smack down. Like, yeah, you're right. It doesn't have anything to do with your defendant, but it has to do with the witnesses that we're going to be calling and corroborating their stories. Have a nice day. Sit down. Shut up. Denied. Because you know you effed up. That's how. This is my thing. If you don't think you did anything wrong, there are certain things that you don't need to hide. I mean, right? Just like certain people not wanting to be served. If you don't think you did anything wrong, man the fuck up. Excuse my language. Huh. In addition, WP was aware that his conversation was being recorded and advised his client not to speak about his case. Relatedly, that portion of the audio provides the helpful context for what immediately precedes the highly relevant audio of what the defendant did when she returned to the courtroom. Listening to the entirety of the audio captures the sudden, unexpected change that occurs when the defendant re-entered and directed WP to step aside from counsel's table without explanation. It is clear by listening to the audio immediately preceding her return to the courtroom that her directive was an unexpected change. It also captures other relevant evidence, such as one witness's immediate impression of what the defendant was doing in the public hallway, and why the defendant's clerk took certain actions before the defendant's return. Oh, the audio will play a conversation in which the defendant's clerk told a state public defender that the defendant was calling the chief judge. The state public defender, who was just in the public hallway, corrected him by sharing his impression of what he just observed. While she's out there confronting them, the clerk will eventually respond, "Good." Like I said, goes back to culture. Huh. Which explains why the clerk went into the public hallway to observe for himself, and then ultimately why the defendant needed to waive for the clerk to accompany her back into the courtroom through the entrance from the public hallway after she had confronted members of the arrest team. And this is why I no longer live in Wisconsin. One of the many reasons. But this kind of culture is one of the reasons that I no longer live in Wisconsin. The defendant does not explain how any of that evidence is unfairly prejudicial, would confuse any issues, would be a waste of time, or would be needlessly cumulative. Less than 3 minutes of audio is not a significant amount of time. Nothing critical is said about the defendant, and rather than confuse any issues, it provides helpful context for the extremely relevant activity that follows it. And while there will be some testimony about what occurs during those less than 3 minutes in the courtroom, playing the audio is not needlessly cumulative. The U.S., because of its heavy burden, is entitled to cumulative evidence. See U.S. v. Gallo. Similarly, the additional 30 seconds of audio that captures activity in the courtroom immediately after scheduling EFR's matters off the record is also relevant. For instance, it captures the state prosecutor talking with another defense attorney, which demonstrates a relevant point. It demonstrates that the defendant did nothing to ensure that the prosecutor was notified or even made aware of what happened in EFR's matter. I mean, I like the way this is written. I'm sorry. Usually I don't like the US, but you know, you know, I'm siding more and more with the government lately, and I'm scared by that. The fact, moreover, will provide a relevant contrast for the jury when they hear the remaining portion of the audio that captures how the defendant addressed other cases in her courtroom that morning. For instance, the audio will demonstrate that the defendant, less than 10 minutes later, told the defense attorney to make sure the prosecutor, who was not participating in the discussion, was aware of dates scheduled off the record so she could make any necessary notification to any alleged victims. The defendant did not do that when EFR's matter was being scheduled off the record. The contrast will be relevant. It will tend to show that the way the defendant handled EFR's matter was hardly routine, an issue which the court already has ruled is relevant and may be explored at trial. See docket 72 at 15, ruling the government may introduce evidence regarding whether defendant handled EFR's case in a customary fashion. At 18, explaining that the court will give the government some leeway at trial to demonstrate the proceedings in EFR's case were handled in an unusual fashion. The 30-second portion also captures the conversation between the defendant's clerk and court reporter. They're both talking about immigration, customs, and enforcement, and the clerk shared with the court court reporter the derogatory term he claimed to have said to one of the federal agents in the public hallway. Their conversation about ICE tends to show that they at least had the immediate impression that the defendant's unusual way of handling EFR's matter was related to ICE and their presence in the hallway that morning. No, the culture in the building. Culture in the building. None of the concerns listed in Rule 403 outweigh this portion of the audio's probative value, let alone substantially so. During this 30-second portion, nothing is said critical of the defendant. There is nothing cumulative about it, and it confuses no issue. The U.S. agrees with the defendant that the court should exclude the 17 minutes preceding the defendant's initial entrance into the courtroom. Everything the audio captures after court was called into session, though, is relevant, and none of its probative value, even when the defendant was briefly away, is substantially outweighed by unfair prejudice, waste of time, any confusion of the issues, or a needless accumulation of evidence. The U.S. therefore requests that the court grant in part and deny in part the defendant's motion in limine. Brad Schimmel. I mean, this is a very Brad Schimmel-esque motion. So yeah, that was a Brad Schimmel is a conservative, by the way, just in case you cared to know. Obviously, the Judge Dugan is not, so I think he's taking this a little personal, but staying respectful because yeah, that could go so many other ways. All right. that is all I have for you guys today. I will be updating the thumbnail and the description of the video to include all the rest of this, and I'm getting better at cutting shorts, um, for my videos. Slowly getting better at things. I did drop a video on the other channel. If you have not seen it, go check it out. It's not my best production value, but I think it's the best scripting, writing work I've done. Um, and it's got some exercises in there. Go try them out. Also started doing a movement minute every Tuesday, where I drop a short on the other channel every Tuesday of an exercise that you could do at home and modifications that you can do to make it easier. Last week or this past Tuesday, it was counter push-ups. So y'all go check that channel out. I am so proud of that channel. I am working hard on that channel. Um, it's it's Jeffrey, I just saw your comment. Shish, shish, shish. All right. Um, shush. Later. I will see you guys on the next one. We might do a video tomorrow. I'm not sure. I am going to be recording a video on the SCORE Act sometime. I still have that to do. I'm working on writing because I can't just talk to a camera like I can to you guys when I'm recording a video. I have to actually write things out, which makes it substantially more time consuming. Getting on a live is easy because I talk to you guys. I know y'all are there. But when I talk to a camera, I'm so like rigid and it's oop, and then editing. I'm finally learning how to use the editing software a little bit better. But, yep, go watch a squid video you choose and hit the like and comment. Yes, please hit the like and comment and share. That channel over there is so important to me. This one is too, but that one is like this over here. We talk, we make fun of people, we judge. Over there is a kind of a judgment-free zone. It is meant to help people, solely help people. This one is meant to be entertainment. That one's meant for educational purposes. So you might need to email me about balance issues you're having. All right. Again, pretend you are live. I'm trying. I'm working on it. I'm working on it. I'm working on it. So y'all have a great day, and I will see you guys on the next one. The only thing I am going to do before we leave is see if there's anybody that I can redirect us to, because when I tried to do it the last time, nobody was coming up. So either nobody was live or nobody had a stream coming up. Let's see if the only Mo in the Deep End stream that's coming up is one she has scheduled for the 10th, which, if you don't know, Mo on the 10th is comparing the um or December 7th, Sunday at 10 a.m. She's talking about dismembered defenses. Mo breaks down Walsh versus Halderson. So Chandler Halderson was in Wisconsin. The Brian Walsh case is currently going on in Massachusetts. She's gonna compare them. So, or at least that's what I'm gathering by her title. But that's not till the 10th. I'm trying to see if I can find anybody that's going live today. Yeah. I thought her and Shizzy were doing streams on Friday afternoons, or Friday evenings, but Shizzy's not coming up either. Like nobody is coming up. Let's see. All right, looks like we're gonna go to naval history. 3 books to understand the USN, RN, and IJN. All right, you go have fun. Tell him I said hi and I sent you over there, and I will see you guys on the next one. Bye bye.